Welcome everybody to the second OHMM webinar in our series. This one is a webinar that our legal subcommittee dreamed up in response to a lot of people that we were doing in-person training or education with, really having questions about what is the current law, how do I avoid getting caught up in the current law. And so we put together a team of a person living with and an attorney. Actually, we have 3 of those teams. Today, you will be seeing one of them to actually to answer those kinds of questions. A couple of housekeeping items. We are offering CEUs that are being provided through Caracol in Cincinnati. At the end of the webinar, I will put up a link that will be to both an evaluation and a quiz. It does the form that you will be directed to asks you, do you want CEUs or not? If you do want CEUs, you need to complete them both. And it will require your license number, all of that kind of good stuff. If you are not looking for CEUs, we'd still love you to go and complete the evaluation so that we can get your feedback. But you do not need to do the quiz, but you can if you'd like to. If you have questions, please direct them into the chat, and we'll make sure to, I will make sure to that our presenters get to see those questions and get them answered. My name is Kim Welter. I use she, her pronouns, and I am the facilitator of the Ohio Health Modernization Movement, which is a coalition. I'm excited to present to you Greg Cody, there's Greg, who is a founding steering committee member for OHMM and the chair of our governance committee. And with Greg is Andy. You want to wave, Andy? And Andy is on our legal subcommittee for OHMM and provides some Ohio-specific legal expertise to us, and we appreciate that. And I'm going to turn it over to Andy and Greg, and they will introduce themselves further. Again, remember, use the chat for questions, and I will get you the information you need for the CEU at the end.
As Kim spoke of, I am with Ohio Health Modernization Movement, Ohio Health, which is a coalition of organizations of individuals dedicated to ending the criminalization of HIV in Ohio. I have been HIV positive for 33 years, and activist, advocate, and here for you if you have any questions. This is Andy.
My name is Andy Dugan. I use he, him, his pronouns. I am the staff attorney with the Equality Ohio Legal Clinic. I am based here in Columbus. The Equality Ohio Legal Clinic provides free legal services to members of the LGBTQ community in Ohio that make less than 300% of the federal poverty level. If you ever do need to reach us, you can call us. You could fill out an intake form on our website, participate in some of our virtual intake hours that we're currently having, since we can't really do a lot of in-person things. And just very briefly, I wanted to give the chance to introduce, many of you may know her as well, but my colleague Emily Meyer, who is a staff attorney in our Cincinnati office.
Yeah, hi, thanks, Andy. Yeah, Emily Meyer, she, her pronouns. I may have seen some of y'all when Andy was mentioning the in-person sort of intake hours that are now virtual. I had, through Rena Severstein at Caracol, set up intake hours at Caracol. Hoping to get back there as soon as we kind of get the all clear and we feel like we're all in a better place to be starting to meet in person. But yeah, excited to be on this call with Andy and be sort of doing these presentations throughout the state in the future.
Cool. Yeah, no, thanks, Emily. So hopefully by the end of today, y'all will have gained some information, general information about HIV, learn how Ohio law criminalizes HIV, understand the legal requirements for a person living with HIV to discuss their status to a potential sexual partner and acceptable methods to do so. And then also acquire some general knowledge about why and how Ohio law should be modernized in this particular area.
Okay. I'm going to discuss what is HIV. A lot of you may know it, but it's nice to have a refresher. HIV means human immunodeficiency virus. It's an identified causative agent which then falls under the umbrella of AIDS. AIDS is acquired immune deficiency syndrome. You need 2 or more opportunistic infections with a positive HIV diagnosis, which then you have an AIDS diagnosis. These separations were important in the early days because it was an issue of funding based on AIDS cases, not HIV diagnoses. HIV was diagnosed 1985. AIDS-related conditions, which are opportunistic infections, are those that you receive or acquire with an HIV diagnosis when your immune system is weakened. PLWHIV means a person living with HIV. We stress and please understand that it's important to put the person first, not the disease, as you continue your process with dealing with people living with HIV. HIV is transmitted through the body fluids which have the protein in them. That would be blood, semen, vaginal fluid, breast milk, and if somebody falls out of a tree or falls, those fluids seeping from the ears are cerebral fluids of the skeletal systems. Those also have HIV. We're not going to talk a lot about those. Those don't happen. Most of them happen during a transmission of person to person. A mother-to-child transmission in the breast milk is determined by the immaturity of the development of the infants, which creates the exposure for HIV.
Just working and trying to avoid coronavirus.
Okay?
Yep, you're good.
Okay.
Or wine.
Why and how? Okay. Why and how HIV laws are important for prevention. Sorry about that, I lost my way, which was my big speech.
Yeah.
Why and how HIV laws are important for prevention. In the early days of HIV, it was easily to tell if somebody was HIV because of the KS, corpuscular sarcoma, which were the purple lesions on a body. In 1995, when the protease inhibitors came out, the new drugs to attack the HIV virus at different places of the replication cycle, there were differences in the body development, abnormal fat deposits, facial tissue losing, and buffalo humps. It was called Crixibilly back there because one of the drugs was Crixivan, though it really wasn't the Crixivan that was causing the disease. Since that time, since 1995, more drugs have come out. We're down to 1 pill a day, which has 3 separate drugs in it. The standard of care is 3 medications, which can be put into 1 pill. On an individual level, decriminalizing HIV or criminalizing HIV was based on a moral compass. My question to you, is it fair to base a decision of somebody's life on somebody's morals? The laws are based out of fear and hate. In the early days, people didn't know how HIV was transmitted. And we were thinking it was caused by mosquitoes. A time of confusion and transmission because of that. Since then, we realized that it was body fluids, not the transmission from mosquitoes. Policies used to discriminate a group of people who are already being oppressed. Is that fair to those people? Do we treat people as individuals, or do we treat them because they have a disease? On a community level, if we decrease the community viral load, which is the amount of virus that is transmittable in a community, if we decrease it down to what is called an undetectable viral load, we decrease the burden of healthcare in the community. And getting people into care and treatment is prevention. If you treat people, you create more opportunities for testing because we get their partners tested. That decreases the community viral load. This also increases dialogue, which will hopefully decrease the oppression of an individual impacted with HIV disease. Empowering individuals to be spokespersons for their own care and treatment, as well as for the community. I hid my disease for years. talking about it with people around me created an empowerment of myself. In creating empowerment for myself, I changed the landscape of HIV. If we do not get people tested, if we do not have dialogues, if we do not change the laws, we do not change that landscape. We do not change HIV. On a treatment personal level, people will not get tested if they know they're at risk for future prosecution. If I know I'm HIV impacted, I am now a potential felon. If I don't get tested and I'm HIV positive, and I engage in sex and infect somebody else, I am not held liable. It's ignorance is bliss, but is it safety? Getting people into care and earlier, they stay healthy longer. Again, that decreases the burden on healthcare. Today, we say HIV is manageable. If we truly are to believe this, we must help manage all aspects of an individual's life. This involves acceptance of the disease and the person as a whole. Changing the laws help an individual see themselves as whole, not broken. The changing of the laws help an individual not live in fear of retaliation. HIV is not a weapon and should not be used as a weapon of control or manipulation, oppression, or discrimination. Back to you.
Oh, one more.
Wait, it's U equals U, which is a new scientific understanding that if we decrease your viral load to less than 200 in a microliter of blood, the amount of HIV, it increases your CD4 cell, which not only makes you healthy, but it also makes you undetectable to somebody else.
Cool. Now, so as Greg was saying, living with a chronic condition should not be criminalized. But that is exactly what Ohio's current law does to people living with HIV in several different statutes. I actually outlined the specific statutes on the slide. When we're talking about the term HIV criminalization, though, what we're specifically talking about is the reliance on a person's positive status, either under criminal laws that apply explicitly to people living with HIV or under some type of general law regarding the transmission of sexual transmitted infections as a foundation for criminalizing otherwise lawful and consensual behavior. These laws started coming up on the books across the country during the 1980s and 1990s. So nearly 20, 30, 40 years ago, at a time when what we know about the virus is not the same as what we know today. Tennessee was actually the first state to get a statute on its books. Ohio joined in the 1990s. All of the statutes, they vary slightly, but generally it may either explicitly criminalize otherwise consensual lawful behavior just because of someone's HIV status and the failure to disclose before sexual conduct, or some type of penalty enhancements. So, you commit an otherwise unlawful activity, but because you're living with HIV, you actually have the chance for a higher penalty, just purely because of, having that condition. Currently, right about approximately 34 states across the country have some type of law on the books that is, again, based on outdated science from a long time ago. So specifically in Ohio, the one statute that everyone seems to focus on a lot with HIV criminalization, which we will talk about at first, is actually the felonious assault statute. So Ohio requires a person living with HIV to disclose one's HIV status prior to sexual conduct or face a second-degree felonious assault charge. That is what the current law in Ohio is. So what is considered sexual conduct? Vaginal intercourse, anal intercourse, oral sex, and also the insertion of any part of someone's body into another person. The penalty is actually quite substantial. So it could be anywhere between 2 and 8 years for each count. Now, mind you, for each count can be each incidence of sexual conduct. So if there were 10 incidences, you may face actually 10 different charges. Also in Ohio, for these charges, they could actually be, there's the difference between concurrent and consecutive sentencing. Concurrent means if you get several different charges and you have several different convictions, you can serve your sentence concurrently. So you're serving them all at the same time and you can get out. So say, you know, you have five convictions, 5 years each, but if you're able to serve it concurrently, 5 years. Here with consecutive, even for, you know, so say there was 5 incidences, and so then it was 8 years a pop, you could technically get sentenced to 40 years in prison. So there are some substantial penalties. It is important that Ohio law also explicitly prohibits anyone who is living with HIV to have any type of sexual conduct with a person living under the age of 18 or a person that lacks the mental capacity to appreciate someone's HIV status. So for younger folks or someone who may not have the mental ability to actually fully realize that. The only affirmative defense in Ohio, so the only thing that a person can do to protect themselves is to affirmatively show that they disclosed one's HIV status to a potential sexual partner before engaging in sexual conduct. The one thing that you may have thought, or a couple things I did not say there, there is no need to prove intent to transmit. So that is not currently under the statute, nor is actual transmission required. It's the failure to disclose prior to sexual conduct. It has nothing to do with the risk of infection or actual transmission. And so those are two things that we'll be talking about that we believe should be changed under Ohio's law. So what might count as disclosure? I know we don't have attorneys, so I'm gonna do my best here, but there was a case several years ago that actually came out of the Cincinnati area that really helped shine some light on what disclosure may mean under Ohio law. So in the case, Mr. Gonzalez engaged in a sexual relationship with a partner for about 4 months. Following the relationship, the relationship ended, and then the sexual partner reached out to a police officer and said that Mr. Gonzalez never actually disclosed his status prior to sexual conduct. So Mr. Gonzalez got charged with 4 separate charges under the felonious assault statute. Now, Mr. Gonzalez also had, in his defense at the trial, he had multiple witnesses to testify to his propensity to disclose his status. He had an ex-girlfriend come that actually testified that yes, he did disclose his status before they engaged in any type of sexual conduct. He had his sister, a family member, also testify regarding his propensity to do that. In addition, he also had a case manager from the AIDS Volunteers of Cincinnati come to testify on his behalf. All that, again, it didn't matter. And the court still actually convicted him under the statute. And so he filed an appeal, and what he argued several different things, but one of the things Mr. Gonzalez argued was that the term disclosure is too vague. What do you mean? Like, what do you want me to prove? Like, I had my ex-girlfriend come, I had, my family member, a case manager. Really, it's just a dispute between the person who made the complaint and the defendant. So it's like, how do I show that I disclosed this? The court didn't buy it. They said that the word disclose is not vague, and that a person of common intelligence would understand it to be meaning to reveal or make known through verbal disclosure. The takeaway of that case, really, it's very difficult to prove that disclosure of someone's HIV status occurred prior to a particular incident of sexual conduct. In some cases, there may be no proof that someone can provide. And then the only evidence is someone's testimony. And again, then you're putting that in the hands of the court whether or not to believe you or the person that was being charged. So if your own testimony and others' testimony might not work, what can count as adequate proof of disclosure? We live in 2020. Most of us have, hopefully, a lot of us have phones with some type of recording technology, either video, audio, something. Recording a verbal disclosure to your partner could be very helpful. Make sure that you have some, that your phone has the capacity to have like timestamps on it. So that you would actually be able to prove either via video or via voice recording or whatever technology you have with that timestamp. You could also request your partner sign a statement. Put it in writing that they acknowledge your disclosure prior to any type of sexual encounter. Also with our phones, screenshots are wonderful. So save screenshots of text messages, social media, dating apps, anything that you are an individual is using to communicate with a potential sexual partner. Screenshot that, save it. Again, that would be great if you have that timestamp right there, and a date as well, just to prove when it was taken. Another thing that might be good is to get it in some type of record. So what an individual could do is bring a potential sexual partner with them to a medical appointment or a social service appointment, and then actually, do the disclosure in front of a caseworker, a medical professional, and have it notated in the records, because then those records could be relied upon that, yes, there was a disclosure, and again, there may actually be another person that would be able to provide testimony that a disclosure did occur. And then, so some people might think, again, I'm not going to go too deep in here, but how is this law constitutional? A lot of people might think that the government cannot compel you to speak. Well, that's what Mr. Batista thought as well. And so Mr. Batista actually brought the case all the way to the Ohio Supreme Court. And it basically said that you are forcing me to talk. You're forcing me to speak. This violates my rights under the First Amendment of the Constitution. The court didn't buy it. And so what they stated was that the statute regulates conduct and that the burden on speech is merely incidental. So just to show that a current constitutional challenge to the Ohio law, it was tried and it failed. Again, though, Ohio does have judicial elections for Ohio Supreme Court. And so with new justices, who knows what might actually happen. But previously, it was a no-go. There's a few other areas of the law where Ohio criminalizes someone just for having HIV. Specifically in regards to sex work, there are enhancements to the statutes for so solicitation, loitering to engage in solicitation, also for any type of spitting, biting, exposure to bodily fluids. And so really what that means is a person cannot in any way expose or attempt to expose another person to your urine, feces, semen, blood, or any other type of bodily substance with the intent to annoy, threaten, alarm, or harass a person. So don't be spitting on someone, don't be throwing bodily fluids or substances on someone. And again, a blanket prohibition, and which is actually a crime if someone who knows that they have HIV attempts to donate blood or sell plasma. And again, there are all of these have sentence enhancements. So if someone is actually convicted for loitering to engage in solicitation or something like that, and if the court is able to prove that they did know about their HIV status before that, there would be sentence enhancements. Yeah, and so what should someone do if they're arrested or risk at arrest? Well, generally speaking, if you are ever arrested or at risk of arrest, ask for an attorney as soon as possible, and do not answer questions with the police without speaking to an attorney. Make it very well known that you want an attorney as well. It is important that you do provide that notice to the police. Otherwise, and I know you should also comply with any law enforcement officials and for what they're telling you to do. But you don't need to comply with everything. Some things that you should not do is someone living with HIV should not disclose or discuss their status in the presence of law enforcement officers. They should not talk about it with anybody other than an attorney. Also, just very important, just in life, you shouldn't be signing anything without first consulting an attorney. Specifically, it is something from a law enforcement, from a prosecutor, anything like that. Also, an individual does not need to consent to any type of medical tests voluntarily. Either a blood draw, saliva swab, anything like that. Under Ohio law, when you have either a conviction or a dismissal, but I'm going to talk specifically about convictions, sometimes you're able to get those either expunged or sealed. There is a difference. So an expungement is really when the records are destroyed. They are only available in very limited circumstances in Ohio. And so generally what those conditions would be is for juvenile convictions, convictions of victims of human trafficking. And since it's Ohio, we have a very specific gun law that can get expunged if you violated that. Generally speaking though, you would need to actually file an application to seal the records. What that means is for most purposes, like potential landlords or employers or schools, things like that, they would not be able to see, so long as the court approved the application and ordered its sealing, they would not be able to see those records. There are some exceptions to that for like state licensing agencies and stuff. That's not important to this discussion. However, a lot of the statutes in Ohio, you're not even eligible to file an application to get it sealed. Particularly the failure to disclose, which is the felonious assault statute. If you have a conviction under that statute, you are not able to file an application to get it sealed. With the asterisk that if an individual was a victim of human trafficking and they did face one of those convictions, under the law, they would be able to pursue that process. But generally, the only ones that you might even be able to seal would be the harassment with a bodily substance or selling or donating blood. And that would determine on a case-by-case eligibility analysis, you need to look at several different factors. But generally speaking, the failure to disclose, if someone has that conviction, that's going to be on their record for the rest of their life. If it's a dismissal, those are different rules and you might be able to. But again, for the conviction, that's there to stay. So why do we need modernized Ohio law? Back to Greg.
Why do we need to modernize? Okay, leading the public health and legal experts believe the laws do need to change. Also, as he talks about body fluids and spitting and everything, laws are changing on organ donations, that they are now legal to donate HIV positive to HIV positive. So everybody is catching up to the understanding of the science of HIV except the laws. So it's important that we help them along on their journey. Ohio law, HIV criminal laws are opposed by the ACLU of Ohio, the National Alliance of the State and Territorial AIDS Directions, which is NASDAD, and the National Association of Criminal Defense Lawyers. The U.S. Department of Justice has recommended that states like Ohio re-examine their HIV criminal laws to better align with the current evidence and consideration whether the laws are the best vehicle to achieve intended purpose. Back in the early days of the epidemic, the intent was to oppress. Why are we oppressing people today? The laws are unfair and stigmatizing. In Ohio, a person living with HIV can go to a prison for 8 years for not disclosing their status before engaging in sexual conduct, even when they did not intend to harm anyone. We all want to be loved, and in this day of COVID-18, I think it's more important to understand the importance of touch and how we are missing it in our community and how it personally affects you. Add to that somebody living with HIV who can't be touched. In the early days of the epidemic, a friend of mine was a nurse who in the early days, they put on a garment, the full gear, and went into the hospital rooms. She went to a person's house and didn't wear the garment, but put her hand on his forearm, and he cried. And she asked, "Why are you crying?" He said, "I was diagnosed 9 months ago, and nobody's touched me since." Whether or not we're living with HIV or not, we are human, and touch is important. It shouldn't be criminalized because we want to engage in what everybody takes for granted. In Ohio, having a felony on your records means restricting on voting rights, your ability to hold public office, serve on unjust jury, access to benefits like public housing. Under Ohio law, some people with HIV will also be required to register as a sex offender. The laws are costly. The money spent to incarcerate people under HIV criminal laws would be outrageous, okay? These are charts. I know it seems like a lot. So hopefully we're gonna send you it's good. So I'm just gonna go through them briefly because I don't think it's important to read them all through. I think they're important, but I think we all could read. One of the things is prove intentionally transmission, which means that you acted with intent and a purpose to transmit HIV. There is a difference between longing for love and acceptance versus an attack on somebody's life. We need to consider the risk reduction, which means if you are using barriers such as condoms or any other protection during the sexual act or any act, does that mean that you are conscious and you are taking care of not only yourself, but your partner, and in doing that, you are taking responsibility. We need to reduce the penalties based on the offense of, proportionate to the harm, which means if you're only engaging, say, in oral sex versus vaginal or intercourse, there is a difference of exposure and possible transmission. We need to look at all the key elements of HIV and separate felony out versus misdemeanors. Okay, we need to prove transmission. If not, how can you prosecute? I have a virus that I've had for 33 years. We can linear line back to where it came from. Okay, that's important because we need to make sure that the virus, the genotype and the phenotype are a match, that was potentially the person who infected you, okay? We need to decrease the penalty for sex workers. It's like double dipping, you know? Remove felony enhancement for bodily fluids. I had a man spit on me, and the officers asked if I would file charges on attempted murder off of spit. That's unacceptable. The man was HIV negative. What if that person was HIV positive? It would have been a whole different dialogue. All right, so moving right along. This is me. Where can you find? Did I miss? Oh, here we are. We talked about undetectable is untransmittable. In this day, we are looking at this. World Health Organizations across every doctor has now proven that an undetectable viral load is not going to transmit HIV. It goes back to what I talked about, believing that an individual is whole, creating an environment that creates that wholeness, that they have the opportunity to go to their doctors, to get treatment, to get into care, to change the social aspects of living with HIV. To change the world means to understand that undetectable means untransmittable. And in doing that, we create a level playing field for everybody living and not impacted with HIV.
we also have some links here, and then we can also share just the Ohio Health Modernization Movement website, OHMM's website. Another great resource is the Center for HIV Law and Policy. They provide great breakdowns of like all 50 states, particularly for Ohio's. It's very detailed. And so if you ever are looking for a very great explanation, I would really suggest that. There's also the SARO Project, and then the National Legal Aid and Defenders Association. And looks like we have the Center for HIV Policy twice, and then the ACLU AIDS Project. So yeah, actually it looks like we kind of made it a little quicker than what we would thought. So what type of questions do people have?
Hey, Andy.
Yeah.
There was a question, but it came privately to me, but I will repeat it because it's a good question. The question was, what is being done as far as educating politicians and lawmakers? Is this the first step in advocating to change HIV laws?
No, actually, for years, it's called AIDS Watch. And what we do is we educate people living individuals impacted with HIV disease and send them off to our state representatives. And they do it on a national level where they go into DC and take it over for a couple of days and go in and present to state representatives and Congress and people to educate them on HIV and AIDS.
Yeah, I think we have not had something similar for Ohio's representatives. So that's kind of where we are now. More private stuff to me. We do have a legislative subcommittee of OHMM, and they have been working to design what our desired language would be, like this would be, well, not quite perfect. Repeal would be great, but we don't see repeal as something that we actually have an option of in Ohio. So we're looking at reform, or the word that we're using, modernize. But that legislative subcommittee has come up with that language, and it is actually now at the what's known as LSC at the State House, where it gets translated from the language we wrote it in to language that is consistent with Ohio law, the way the rest of Ohio laws are written and phrased. And it's still in that drafting stage there. We are currently looking for the sponsors, who would be the sponsor of that legislation, and we are hoping for bipartisan sponsorship of this bill. It is much easier for us to get the attention of at least state legislators, when we actually have like a bill we can point them to. Frequently when we have conversations now with legislators, they'll say, well, I'll need to see the language. And so right now our concentration is on getting that language. I will admit that COVID-19 and the State House being social distancing for quite a while, and now current events have taken up the legislature's attention. And we did not anticipate that, but we still keep moving forward in hopes of getting actually a bill introduced. We do have a webinar. If you were to go to our website, ohiohealthmm.org.com, I forget at the moment, I'm sorry, but I'm going to send you an email that will have a follow-up with that website. But if you go there and you go to webinars, and you look at our May webinar, the May webinar is recorded and available to you, goes over, what is all that language and such. And it might be a good resource for you. Andy, you now have a question to everyone.
Okay.
One, how long do you anticipate?
Oh no.
Anticipate the language for how long do you anticipate AIDS Watch that you discussed? Hold on, I'm having unstable connection. That you just open to the public, or only the speakers and state reps? So first was how long do we anticipate before that bill is completed? I can answer that if you don't want to take it, Andy.
Oh yeah, go ahead, Kim.
Okay. It could be any day. They've sent us back a series of questions of ways that they want to make the language make more sense with the way the rest of Ohio law. We believe we've given all of those answers at this point. So at any day that language could be completed. And then Greg, I'll send you the second question. Is AIDS Watch open to the public or only the speakers and state reps?
No, we'll speak to anyone. And if you want us to speak to somebody, if you have an organization that you want those living with HIV, I have a group of advocates that I work with that will be happy to go. If you want to participate and go to AIDS Watch or DC, you don't have to be HIV infected, okay? Because in reality, we are all HIV infected. We're affected. So having anybody aboard to be a part of it creates diversity. Diversity creates change.
Also, Jerry Malakote, thanks Jerry, who's the chair of the legislative subcommittee for OHMM, does point out that we have a legislator education toolkit that they review in that May webinar that is recorded on our website, and that has talking points and other supporting educational materials that you could give to legislators. Right now that's all available electronically. I remind people that I'm willing to put together physical packets to hand to a legislator. It's just that right now with social distancing, etc., it's very difficult for us to give those to you, but it is possible. So if you would like something physical to hand a legislator, then you would contact me, Kim, at equalityohio.org, and I can make that happen. So there's a question about, do we have prospective sponsors that look promising for support? Yeah, actually we do. We're not prepared to make those names public at this point. We'd rather wait until we have full sign-on to that. And it's, as I mentioned, it's the bipartisan support that we look at that tends to make this slightly more difficult. Seeing if there's any more questions. All right, so as some closing housekeeping, although if you have another question occur to you, please type it in there. One, that we are making these a monthly, oops, we do another question.
Yep. Okay. So
okay, Andy,
so,
could you clarify, Andy,
sexual conduct.
Oh, thanks.
Okay, so sexual conduct means vaginal intercourse, anal intercourse, oral sex, and then the insertion, however slight, of any part of the body into the vaginal or anal opening of another. However slight penetration is enough to satisfy the statute. So that is pretty explicit. That is exactly what that would count. And so then I'm seeing the question, would mutual masturbation, wouldn't it count? Again, so you would have to look to see. And so long as you are not physically inserting anything into the other person's vaginal or anal cavity, or engaging in any type of oral sex, technically under the that would not be necessarily covered. But again, you would have to really, that is a very specific question and a very specific scenario. I'll be frank, I'm thinking of it as a man. And so a woman may have a different take about it. So, but again, it would really just depend on exactly what is included in mutual masturbation.
And again, I think part of the problem is that it'd still be one person says one thing and another person says another thing. And that's problematic. One of the things that we are looking at is in modernizing the law is to make sure that what's covered is only what has a possibility of transferring the virus. So that, if we modernize the law, then that question of mutual masturbation would not be an issue anymore. We would not have counted it at all. But that's part of, this modernizing is making sure that we've defined sexual conduct in a way that actually matches the science, the current science. There was a question about how long has OHMM been working towards advocating for legal change. So I've been involved with OHMM since 2017, but they predate me. But we have been only actively working with legislators and on language for the last 2.5 to 3 years. There is also an additional question. Are we anticipating large public support for these reforms, and what do you see as your challenges in that regard? Greg, you want to take that?
What was the question again?
Are you anticipating large public support for these reforms, and what do you see as your challenges in that regard?
Actually, yeah, there's a whole change in the attitude and atmosphere around HIV. In the early days when I said I was HIV positive, people would step back, run away, wouldn't want to touch. Now I tell people I'm HIV positive, like, oh, my cousin was, my uncle was. There's now a connection with everybody in the relationship with HIV. And in that aspect, we're changing the cascade of HIV. I will tell you, I worked for the Ohio AIDS Coalition in the early days. We didn't touch this because in the early days, we were fighting for equality for all people living with HIV. Ohio AIDS Coalition was very adamant in changing the Title I money in the old days, where for years, Cleveland, Ohio Cuyahoga County got $7 million that was only used in Cuyahoga County, which means people in Portsmouth, Ohio received nothing. We changed the Title I money so that it's spread out through the whole state, which equalizes. And when equalizing—
10 minutes left, and we have—
Okay, I'm sorry. So back to the main question. There is a greater push within the communities to create a level playing field for all people, whether they are living with HIV or not. So to answer your question, yes, there is a movement, there is a support. You don't have to be HIV positive to be a part of this movement.
I think one of the things that we've been very
Oh no, Kim, no.
careful is we don't want any other buddy, and we do not want to raise any of them above that level. So we're very much into minimizing the penalty on HIV and not raising anybody else up. I mean, that whole COVID-19 issue right now with criminalizing it is kind of comes to mind. We do have a question. Is there anything for us to do now, or do we need to wait until the bill is introduced and then approach our representatives? Lisa, I would recommend the webinar that was done in May that's recorded. So, if you've been through that May webinar and can make an appointment with a legislator, one of the folks from OHMM would be totally willing to support you in that, either just through talking it through or actually going with you. But if you have the opportunity to talk to a legislator, please contact me and I can put you in touch with whoever makes the most sense to support you in that, either with materials or company. All of that can be done. As I mentioned, it will be helpful in talking to legislators once we actually have a bill that for them to see and look at, so that pushback that sometimes we get, well, I can't really say how I feel about it until I see the the language, that would already be available. But it doesn't mean you shouldn't speak to anyone. So that's the May. I do want to, we're now running into 10 minutes, so I want to finish this up. We do have monthly webinars. Next month, we're going to actually talk, we will have Jacob Schneider from CHLP, the Center for HIV Law and Policy, and Ohio's own Bob Bucklew. We'll be talking about molecular surveillance and how that plays into this entire effort. So that'll be on July 14th, same time, 12 noon. That invitation will come out tomorrow, barring any something I'm not thinking about right now, but that invitation should come out shortly. And this particular webinar, we already have plans to repeat a couple of times a year. I don't have it on the calendar yet, but I would expect we will repeat it in the fall. If you know folks who would be really like to join one of these live, they can. Otherwise, later this week, this webinar, this recording of this webinar will be available on our website for people to watch. They will also have the option to, until, I know Adam's on here, until September, I believe, they could also get CEUs by watching the recorded version. I am going to, whoops, I am going to get you the, I thought I had it in my queue. Sorry, folks, for the delay. I'm going to get you the link for the CEUs at this moment. There it is. And I also will be, to folks who did register for this webinar, I will be sending a follow-up email that will have that link in it. But if you can go grab it, or, and again, remember, if you want CEUs, we need you to fill out both the evaluation and the quiz. The quiz is the piece that proves that you were here and that you were actually paying attention, so that we can give you the CEUs. And Adam at Caracol does confirm that the recorded version can, CEUs can be given for watching the recorded version until September.
And please be honest in the evaluation. This is the first one that we're doing. So yeah, you won't hurt our feelings. So yeah, please let us know.
Thank you, everyone. We really appreciate you giving your lunch hour to us, and we hope to see you back on July 14th for a webinar on molecular surveillance and how it plays into modernizing Ohio's criminal code.
Awesome. Thank you, everyone.
Thank you.
Thank you.
Hey, Kim, if you stay on, I have a couple pieces of mail I wanted to show you to see if they might be yours.
It's recording.
And then